Hello students and welcome to the next session of company law. In last previous sessions, we have discussed about the accounts of the company. Then we talk about the corporate social responsibility provisions and internal auditor provisions. So we have completed that particular chapter. Now we are going to move on to the next topic of the company law. The topic name is Audit and Auditors. The topic name is Audit and Auditors. So here we are going to talk about the statutory audits which are conducted by the auditors of the company. Now here in this particular chapter we'll try to understand about the appointment of the auditor. Then what are the requirements, qualifications, disqualifications for becoming the auditor. We will also talk about the removal process of the auditors, then duties of the auditors, how the audit report should be submitted, all those provisions. Okay, so let's begin with the topic. So our today's topic is audit and auditor. Now one question will come to your mind, why the auditor is required and why this audit process is required. So try to understand, when any large business corporations are managed, those corporations are managed by the directors who represent the members, and members are the real owners of the company. So far we have understood it. So if in absence of any particular check, the directors may mismanage the funds or the finances of such large corporation or large companies, you can say. Thus, members appoint auditors. So, members only appoint directors. At the same time, members only appoint auditors to look into the true and the fair view of the financial affairs of the company. And these auditors are basically independent from the management of the company, and that is the reason we can say that they can express their unbiased opinions to the shareholders. So that is the reason we require the appointment of the auditors. Now let's begin with the topic. The provisions relating to the appointment auditor. The first provision is given under 139, appointment of auditor. Section number 139. Just a moment. So 139 provides the provisions relating to the appointment of auditor, which says that every company shall at the first general meeting should have the auditor, should appoint the auditor. Okay, appoint an individual or a firm as an auditor of the company. The auditor shall hold office from the conclusion of the first AGM till the conclusion of its 6th AGM, and thereafter till the conclusion of every 6th AGM. So now we'll try to understand how the auditors get appointed, okay, and then we'll try to understand the requirement of it. So we can say that every company first AGM appoint an individual or firm as auditor. The auditor shall hold office from conclusion of first AGM till conclusion of 6th AGM. So the auditor provisions are given under the rules of companies audit and auditor rules 2014. So the rule says that, okay, manner and procedure of the auditor. So where it is given, the manner and procedure of selection and appointment of auditors is given under companies audit and auditors rules 2014. So which says that a company which is required to appoint the audit committee, so competent authority is audit committee. So it will shall take into consideration the qualification and experience of the auditor, and where the audit committee is not required, the board of directors. And then after that, okay, it will give the recommendation to the shareholders of the company, and the shareholders will appoint the auditor. So that is the process, okay, given under the Companies Act and the rules made thereunder. So basically, when the board agrees with the recommendations, audit committee will give recommendation to the board of directors. The board of directors will further recommend the appointment of the auditor to its members. If board disagrees with the recommendation of the audit committee, it may refer back to the audit committee for that particular purpose, citing reasons, okay, of course. And then audit committee, after again reconsidering, okay, may change the name of the auditor, and it can recommend to the board of directors, and board of directors in turn then recommend it to the shareholders. So before the appointment is being made of the auditor consent is required. Before appointment, the written consent of the auditor to such appointment, or you can say auditor is required. Okay, that is the mandatory condition. Now there can be a kind of certificate which can be required, like the auditor should submit a certificate that the individual or the firm, as the case may be, is eligible for the appointment, is not disqualified for the appointment as per the chartered accountant rules. The proposed appointment which is to be made, okay, is as per the limits laid down by or under the authority of the act, and the list of proceedings, if any, given by, okay, which are against the firm or the individual, relating to the professional misconduct, you can say, everything, okay, should be properly mentioned. It will also indicate that auditor satisfies the criteria as per section 141, which provides for the qualification, disqualification of the auditor. Okay, so before appointment, written consent is required. Also, certificate, you can say certificate of fitness from auditor is required. Then After that, company will inform the auditor concerned of his appointment. So after appointment, company shall inform the auditor concerned, auditor whoever has been appointed, of his or its appointment if it is a firm, company will also file form ADT 1 with ROC. Within 15 days. Okay, so these are some of the important requirements of the appointment of the auditor. Now these are given under section 139 subsection 1 and the rules made thereunder. So again, okay, we will just go through it. Every company shall at first AGM appoint an individual or a firm. So it can be individual or firm as auditor. So it will hold office from the conclusion of first AGM till 6th AGM. We will talk about the term of the auditor as well. The manner of appointment is given under Companies Auditor and Auditors Rules 2014. Before appointment, the written consent will be required from the auditor. Also, the certificate of fitness will be required from the auditor that the person or individual or the firm is fit enough to be appointed as the auditor. After appointment, company shall inform the auditor about its appointment. The company will have to make the communication by filing form ADT 1 to the ROC. Okay, so this much we have completed. Now we'll talk about the term of the auditor. What is mean by term of the auditor? Term of auditor is given under section 139 subsection 2. Okay, which says that the listed companies or other classified class of companies except one person and the small company shall not appoint or reappoint an individual auditor for more than one term of 5 consecutive years. So we says that listed companies and other specified companies shall not appoint reappoint shall not appoint or reappoint. So it may be in two cases, individual, okay, or you can say the audit firm, okay. So it may be with the case of individual or it may be with the case of audit firm. So you can say for more than one term of 5 consecutive years, and here also for more than 2 terms of 5 consecutive years. So you need to just refer one term, and here 2 terms are given. Okay, so only one term is given, and here 2 terms are given for the audit firms. So an individual to be appointed as the auditor, he can only be appointed as the auditor for a term of 5 years, and audit firm can be appointed for 2 terms of the 5 consecutive years, because in audit firms you will have different partners as the auditors, but the same partner should not be there for the 2 consecutive terms. Now there is a cooling period given. Cooling period. So cooling period for individual, it is who has completed his term, shall not be eligible for the reappointment for 5 years from the completion of his term, and audit firm which has completed his term shall not be eligible for the reappointment for 5 years from the completion of such term. So what is the cooling period? Again it is divided into 2. So if it is individual and audit firm, it is individual and audit firm. So what is the cooling period? You can say shall not be eligible for reappointment for in same company for 5 years after completion of term. Okay, so after completion of the term for the 5 years it is not eligible, and this is the similar again provision for audit firm as well. So for the next 5 years it will not be eligible for the completion. So that is the cooling period which a company will have to complete, okay, in order to again become the auditor of the same company. Further, there is one requirement that as on the date of the appointment of no audit firm having a common partner or partners to the other audit firm whose tenure has expired in the company immediately preceding the financial year shall be reappointed as the audit firm of the same company for a period of 5 years. So companies, even the partner audit firms, they will have to ensure that whoever is the partner, okay. So I can just give you an example. Let's assume that there is a ABC, okay, audit firm having 2 partners, A and B, okay, and B has is also partner of another audit firm, okay. Let's say that XYZ. Now ABC is appointed as the auditors in the company, okay. Let's assume that in Reliance Industries, for example, for 2 consecutive periods of 5 years. Now ABC wants, so that is Reliance wants to, okay, appoint the other auditor, okay, XYZ firm. It cannot do so because Mr. B is again the partner, common partner between these 2 firms, okay. So though this prohibition will be made applicable for the 5 years. What is a transitional period? So every company have existing on or before the commencement which is required, so that for that the transition was given. So this is with regards to the you can say term of the auditor. So we have completed appointment of the auditor, term of the auditor, and the cooling period also we have understood. Now we'll talk about rotation of the auditor. Provisions relating to rotation of auditor. 139 subsection 3. What is meant by rotation of auditor? So this provision says that members of the company may resolve to provide that in the auditor, I think on 4 will also be applicable. In the audit firm appointed by them, the auditing partner and his team shall be rotated at such interval as may be resolved by the members. So in case of the audit firm, okay, the members, the partners of the audit firm should be rotated. The audit shall be conducted by more than one partner, one auditor also. Okay. The CG may by rules manner in the companies shall rotate their auditors. So who can decide? First of all, first members of company may by resolution provide that intervals for rotation of auditors in case of audit firm. So this is applicable in case of audit firm. Okay. Even CG may by rules prescribe the manner of the rotation. Central government may by rules prescribe the rotation procedures. So manner of rotation of auditors by the company on expiry of their term, okay, is given under Companies Audit and Auditor Rules as well 2014. The audit committee may recommend, shall recommend to the board the name of the individual auditor or an audit who may replace the incumbent auditor on the expiry of the term. And where the audit committee is not required, okay, the board of directors can do it. We'll talk about the first auditors. So normally when the company gets incorporated, okay, the first auditor should be appointed. Section 139(6), which says that, okay, notwithstanding anything contained, okay, the first auditor of a company other than the government company shall be appointed by the board of directors within 30 days. But the auditors who are appointed by the board will hold the office till conclusion of the first AGM. So who can appoint the first auditors? Board may appoint first auditor within 30 days of incorporation. First auditor may hold office until the conclusion of AGM, or you can say first AGM, conclusion of first AGM. Okay, so first auditor can be appointed by the board of directors, and then the company will conduct the AGM, and that particular auditor may hold office till the conclusion of the next AGM, the first AGM. And if board fails to exercise the appointment of the auditor, then board will inform the members about it, and the company may appoint the first auditor within 90 days at an extraordinary general meeting, because company will have to then conduct the extraordinary general meeting for that particular purpose. I'm just taking you through the important provisions of it. 139. Then filling up casual vacancy, section 139(8). So casual vacancy, how it can be filled up. So who can fill up casual vacancy? The board is authorized to do that. Board may fill up any casual vacancy in the office of an auditor within 30 days. Any auditor appointed in a casual vacancy shall hold office until conclusion of next AGM. Okay, so casual vacancy has to be filled up within 30 days, which can be filled up by board of directors, but he can only hold the office till next AGM. So this is a provision relating to the casual vacancy. So in case of the government companies, there are different provisions. Appointment of the auditors for the government companies, it should be as per the CAG, Controller and Auditor General of India. Okay, shall in the financial year appoint the auditor duly qualified for the government company which is controlled by the central or state government. So auditor shall be appointed within a period of 180 days from the commencement of the financial year. So that is a provision for the you can say for the government companies. So whether there can be the reappointment of the auditor. So retiring auditor may be reappointed at the AGM if he is not disqualified. So the reappointment provisions are given. Reappointment of retiring auditor. Reappointment of retiring auditor. These provisions are given under section 139, 9, 10 and 11. So reappointment, retiring auditor may be reappointed at the AGM if he is not disqualified for the reappointment, if he has not given the company a notice in writing of unwillingness to be reappointed, and a special resolution has not been passed for the some other auditor. So he is eligible for the reappointment. Okay, so we can say he is eligible for that. So where the in AGM no auditor is appointed or reappointed, the existing auditor shall continue to be the auditor of the company. So basically he is eligible for reappointment if he is not falling under any of the disqualifications. So we have talked about the important provisions of 139. I hope you have understood it. You please make a note of all these provisions. So far we have talked about the appointment, then the reappointment provisions. Now let's talk about the removal and resignation of the auditor. Removal. Removal. Resignation of auditor. Removal, resignation of auditor. Okay, so removal, resignation of auditor, the provisions are given under section 140, which says that okay, auditor appointment may be removed from the office. So auditor appointed as per whatever we have talked about, as per provisions of the 139, may be removed by giving a special notice if the special notice is received for the removal of auditor. Okay, if a special notice is received for the removal of auditor, he may be removed. But for that, okay, you need to acquire the approval, or you can say consent of the central government as well. So what are the steps? We will very quickly try to understand. a special notice, okay, is received. That is step number 1 for removal. This is my step number 1. Then my step number 2 would be board resolution, board meeting will be held for removal. Step number 3, then application to CG, okay, inform ADT 2 within 30 days from board meeting. Then my step number 4, auditor shall be given an opportunity Then my step number 5, after approval of CG, special resolution, and then 6, auditor can be removed. So it's not that easy process that shareholders only can take the decision, because once you appoint the auditor, okay, it may so happen he may give some remarks, observations to the company, so he should be protected properly, and every opportunity should be given to him to represent himself. So in this way he may be removed from the company. This is regarding the removal. Okay, it will talk about the resignation of the auditor. Okay, so resignation, if the auditor has resigned from the company, he shall file within a period of 30 days a statement in the form of ADT 3 with the company and registrar. So in case of resignation, of auditor, if auditor has resigned, he shall file within 30 days form ADT 3 with company and ROC. Auditor shall indicate reasons and other facts for resignation. If auditor does not comply then he shall be liable for a penalty of 50,000 or an equal amount of remuneration. Okay, and the then penalty. Okay, so these are the some of the facts, okay, for the removal and the resignation of the auditor. So appointing the auditor other than the retirement auditor, if the retiring auditor has not completed a consecutive tenure of 5 years or 10 years, okay, the special notice will be required for a resolution at an annual general meeting appointing an auditor, a person other than a retiring auditor. So these are some of the provisions we have seen. Now we'll talk about eligibility, qualification and disqualification of auditors. Or you can say qualifications and disqualifications of auditors. Section 141. Okay, so qualification is basically he should be a person eligible to be appointed as auditor, and he should be chartered accountant. A firm where the majority of the partners practicing in India are qualified chartered accountant, and where a firm including LLP is appointed as auditor, only the partners who are chartered accountants shall be authorized to act and sign on behalf of the firm. So basically, what is the qualification? So qualification you can say in two ways. So if it is individual, okay, then if it is the audit firm, should be CA, and majority of the partners should be CA. Okay, so what is the disqualification criteria? The following persons basically will not be qualified. So body corporate other than the LLP register under LLP Act, an officer or employee of the company, a person who is, so we'll talk about the disqualification also. So disqualifications very quickly. So what are the various disqualifications? So you can say following persons shall not be qualified for appointment as auditor. The first one is a body corporate other than LLP. So LLP is allowed to be appointed as an officer or employee, an officer or employee of company is disqualified so you can say these persons person who or his relatives or partner is holding any security of or interest in the company. So of course thresholds are given, and that as per those thresholds, okay, one can hold securities but not beyond that. So these are the facts about the appointment of auditors. You may just make a note of these points. Removal we have done. Then resignation and qualification, disqualification. Now we'll talk about remuneration of auditor. Remuneration of auditors, section 142. So this talks about remuneration of the auditor, which shall be fixed by the company in AGM. It shall be fixed by company in AGM, okay, as per the manner prescribed. For the first auditor, for first auditors may be fixed by board of directors. So in addition to the fees payable, okay, the expenses and other part also can be given to the auditors. So this is regarding that. Then powers and duties of auditors. What are the main powers and duties of auditors? Powers and duties of auditors are basically given under section 143. Okay, so what are the powers of the auditors? So when we say powers of the auditor, so powers, we can say various powers are given to the auditor, that access, he can have access to the books of accounts and the vouchers, books of accounts and books and papers he can have access. Okay, he is entitled to have the necessary information and explanation. entitled to have necessary information and explanation, and then access to records of all its subsidiaries. Access to record of all its subsidiaries. Okay, so these are his some of the duties. Okay, he should have access to all the subsidiaries, associate companies also. He can have access to the books of accounts. He is entitled for the information and explanation. Okay, so what are his duties? Duties are very important. So duties are basically, you can say, so he has a duty of matters of inquiry. He can have the duty to inquire into the auditor can inquire into various matters. An auditor can inquire into various matters. Okay, so which particular matters he can inquire into, like the loans and the advances made by the company, whether on the basis of security have been properly secured, whether transactions of the company which are represented in the books of entries are prejudicial to the interest of the company or not, where the company not being an investment company, okay, whether so much of the assets of the company of shares, debentures have been sold at a price less than it or not, whether it has been properly made as a deposit, the loans and advances, whether the personal expenses have been charged to revenue account. So all these basically matters, okay, he can inquire into. The auditor shall make a report to the members of the company on the following: on the accounts examined by him, an auditor shall make a report to the members on the accounts examined by him. Then auditor, while making the report, shall take into account the provisions of the Act, accounting and audited standards. He has to comply with the accounting and auditing standards. He has to express his opinion on accounts and financial statements examined by him. He has to provide auditor's report. Then he has to provide auditor's report. Okay, he has to provide auditor's report, which will state the various facts, whether he has sought or obtained all information, whether in his opinion proper books of account are required by the law where the company is maintaining, whether all the accounts of the branch office are properly maintained, balance sheets, profit and loss accounts dealt with the report are in agreement with the books of accounts and returns, whether the financial statement comply with the accounting standards, or observations, comments, anything, okay, whether any director is disqualified, any qualification, reservation, adverse remark relating to the maintenance of accounts, whether the company has adequate internal financial controls. So all this information he has to provide. These are his duties. Then there are certain miscellaneous provisions given over here. Auditor not to render certain services. Auditor not to render certain services which are given under section 144. So auditor appointed should not provide company with certain services like accounting and bookkeeping service, internal audit, actuarial service. Such type of services should not be provided. So we can just put few names: accounting and bookkeeping service. So actually he should not be a consultant for the company for other matters. Internal audit definitely he should not provide, because he is the outsider who will look into the matters. Actuarial service, design and implementation of financial FIS, you can say financial information system. Investment advisory or banking service, investment banking service, management service. So these services he has been debarred from performing. He should not directly or indirectly also provide such kind of services. Then after this, auditors to sign the audit reports. The provision is given: auditor to sign audit report. Section 145 states that auditor is required to sign the audit report, and he will certify the other documents of the company in accordance with the provisions. Qualification, observation, comments on the financial transaction, he can just give it to the company. Then there are certain provisions which I am just mentioning over here. Auditors to attend AGM. So auditor can attend the AGM. He is allowed to attend the AGM. So all notices, communication should be given to him to attend the AGM. Auditor shall, unless otherwise exempted, attend either himself or through his legal representative. He shall be heard. He has a right to speak in the during the meeting whenever the question will be raised for the audit purpose of financial statements. And there are penalty section, punishment for the contravention. Punishment for contravention. So this particular section is provisions are provided under section 147. So there are three types of punishment: penalty for a company, penalty for the officers, and penalty for the on the auditor. So these three particular sections you can say given: penalty for company, penalty on company, you can say, penalty on officers, and penalty on auditor. So what is a penalty on company? If company makes any kind of contravention, the company shall be punishable with fine of rupees 25,000 to rupees 5 lakhs. In case of the officer, okay, there can be imprisonment up to 1 year, or there can be fine 10,000 to 1 lakh. And if it is the auditor, okay, so if an auditor the company contravenes any of the provisions, then there are different provisions for it. Okay, again there are two types of provisions: imprisonment up to 1 year, or fine rupees 50,000 to 25 lakhs. There can be liability on the firm as well. Okay, so these are the provisions we have studied today. So we have completed the audit and auditor part, the appointment of the auditor. So we have discussed about the appointment of the auditor, then we talk about the rotation of the auditor provisions, removal and resignation of the auditor, qualification, disqualification of the auditors, remuneration part of the auditor, powers and duties of the auditors, and then auditor should not provide certain services, and there are some miscellaneous provisions regarding signing of audit report, attending the AGM, and the punishment for the contravention. I hope you have understood all these provisions very well. Please do watch this video, read the notes. Thank you so much for attending this video. We'll meet very soon, okay, with the new topic. Till then, goodbye.